All right, I want to start by thanking the Friends of the Missouri State Archives for having me and for supporting the research that led to my book, which you see up here on the screen. I also want to thank Tracy Wegman and Brian Rogers for arranging all of the details of the visit. I really appreciate their kindness and generosity. So I want to start tonight by telling you a little bit about how I came to this project. I'm from Ohio, I'm not from Missouri, and I did my doctoral research at Duke. So how did I end up in St. Louis and working on these freedom suits? Well, it started in college. I started college as a pre-law, in the pre-law program at Delaney, and I loved history. I knew I wanted to study history, but I thought, I'm gonna be a lawyer, I'm gonna go to law school. And so my sophomore year of college, I took a course on slavery and freedom in the Antebellum South. And as part of that course, we read this narrative by Solomon Northup, 12 Years a Slave. Some of you may recognize that story. It's been made much more famous by the feature film of a few years ago. And when I read this, as an Ohio resident, I felt like I really hadn't heard that much about slavery. I didn't really understand much about the system. And what really captivated me about Solomon Northup's story is how he was a free man living in New York, and then he was kidnapped and sold into slavery, and his status changed virtually overnight. And yet he's also able to eventually return to freedom, sorry, spoiler alert if you haven't read the narrative, and write this book. And so how did that work? I was fascinated, but I thought, no, I'm still gonna go to law school. And then a couple years later, I was fortunate enough to take a course from the late Dr. Judy Schaefer at Tulane, who was a legal historian of slavery and the law. Sorry, I forgot to take water before I started. Rookie mistake. So in Dr. Schaefer's class, let me know that I could combine my interest in law and history as a career, and more importantly, she taught me about the legal history of slavery. So at the time I took her course, she had published this book that you see on the left of your screen on slavery and the Supreme Court of Louisiana. And then she was currently working, while she was teaching me, on the book on the right side of the screen, which is about really about slavery and freedom in New Orleans. So freedom suits, or people suing for their freedom, were a big part of her research for that book. And so under her direction, as a senior, I wrote a senior thesis on a Louisiana woman held in slavery who sued for her freedom and the freedom of her 16 children and grandchildren. And so that makes it all the way to Louisiana Supreme Court. I did a very in-depth study. It came out of Point Coupé Parish, Louisiana. And so that's when I really started to get into these issues of freedom suits and suing for freedom. So I started my doctoral research at Duke, thinking I want to do something on slavery and freedom, but I'm not really sure what. And it was Dr. Schaefer actually who sent me an email and made me aware of a new project, new at the time, called the St. Louis Circuit Court Historical Records Project. Now some of you may know this. I don't have the link up here, I wish I did. But if you don't know it, this project actually went through because of the notoriety of the Dred Scott case. They won a federal grant, and they were able to go through and select all of the freedom suits they could find from the St. Louis Circuit Court, and they digitized these and made them available online. And so Dr. Schaefer had heard about this, but she was, deep into her research on the book about New Orleans, and she said, "Are you still looking for a dissertation topic? Would this be something you might be interested in looking at?" And so I thought, okay, I'll give this a try. And so while I was starting my research, I just was fascinated by the stories coming out of the cases. So it was really the stories of the enslaved people suing for freedom in St. Louis that drew me in to this particular research project. And it was the notoriety of Dred and Harriet Scott, who you see pictured here, that really made that all possible. Now I assume most of you have probably heard of Dred Scott, but just in case you haven't or you don't know the details, I'll just mention briefly that Dred and his wife Harriet sued for their freedom in the St. Louis Circuit Court starting in 1846. Now in that initial case, at the circuit court level, they do win their freedom. They based their case on an argument that I'll talk about in just a minute, that they had lived in free territory. And so that argument is pretty common. You'll notice on your handout, I promise I'll talk about that more in a minute, that's a very common argument in these cases. And so that was the argument they brought. That argument had been pretty successful, and so they win at the circuit court level. When they appeal to the Missouri Supreme Court, that's when everything changes. The Supreme Court, the composition of the court, the judges on the court had changed by that point. And so the Supreme Court says, times are not now what they once were. This is in 1852. And so they're responding there to sort of political currents around the nation and debates over slavery and particularly the future of slavery in the West and in the territories. And so they reverse years of precedent and decide against Dred and Harriet's freedom. And that's when, with the assistance of families in St. Louis, they're able to appeal their case all the way to the United States Supreme Court, which issued its 1857 decision declaring that no African Americans, enslaved or free, had legal standing to bring a case in federal court, essentially denying citizenship rights to African Americans. And that's what made this case so famous, this 1857 case. It's often listed as one of the main causes or one of the contributing factors to the secession crisis and the American Civil War. So my interests in slavery and freedom and law are what led me to this project. And I looked at just over 300 cases of enslaved people from the 18 teens to 1860. And I was most interested in these issues of slavery and freedom. What's the line between the two? How are these decisions being made? And I still think that's one of the most interesting things about these cases. But what I've discovered through years of dissertation writing and then book writing is that they have a lot to teach us about how law works in people's daily lives, what I will talk about in a minute as legal culture. They also have much to teach us about mobility, how people moved around and what that meant in their lives, about politics and the contributions of enslaved people in particular to the political arena. Now, I'm not going to go into a lot of detail about all of that, but what I want to share with you today is a few of the key points from the book. But before I do that, I want to talk a little bit more about the research that I did. So this is from your handout here. You can see the total number of cases here at 286. If you are familiar with the online project, you'll notice that the 286 is actually less than the number of cases online. And that's because I limited this to just cases where the outcome was whether or not that person was enslaved or free. So there's a number of cases that are part of the project that are related to these cases, but are not necessarily what I term to be freedom suits. And so this is really the heart of the research, but I also wanted to know how the St. Louis story fits with other places. And so to get a sense of that, I read about 800 decisions of state Supreme Court freedom suits from around the country. And you do find these cases in absolutely every state, in every slaveholding state in the country. And then I looked at additional court records, so that's when I was spending quite a bit of time at the St. Louis branch of the state archives to do that. So how do these cases work? How do people actually bring a legal case? Well, in Missouri and in all of the slaveholding states, I didn't find a statute in North Carolina, but most states have statutes that you see here on the left, specifically allowing people to sue for their freedom and providing the means and providing the process for them to do that. And so the process works by if a person believes that they are illegally held in slavery, so if they do not believe they should be legally enslaved, they can approach the court, and the court is actually going to appoint an attorney for them. Now, up until 1845 in Missouri, the state would actually cover the costs of that attorney if the person lost their case. So if they lose their case, the state's going to cover the expenses. If they win their case, the defendant, the slaveholder, is going to be the one covering the costs of that case. Now in 1845, that changes. The Missouri legislature passes a new law requiring that if you're going to bring a case for your freedom, you have to put up some sort of financial resources to make sure that you can cover the costs of the suit. It's what they call a bond of security. And so, as you might imagine, that requirement, that 1845 requirement, does make it much more difficult for enslaved people to bring freedom suits, because most enslaved people are not going to have a lot of access to financial resources. So that does change the course of these cases quite a bit. So once a person approaches the court, they get an attorney and they file a petition kind of explaining their reasons for freedom. And this image you see on the right here is an image of one of the petitions, the end of the petition by a woman named Susan. Let's see if I can point it up right there. It says Susan by M. McGurk or Matthias McGurk. He's one of the St. Louis attorneys responsible for some of these cases. That's just to give you a sense of what some of the documents look like. You can find all of them looking just like that up online on the project if you'd like, and I encourage you to do that. So once a person approaches the court, they have to explain why they sue. And they sue for a whole variety of reasons. I've categorized them here into 3 primary categories, and then of course unknown, because sometimes we don't actually know why it is that they sue. And so I'm going to talk about these in somewhat reverse order. So the first category I'm going to talk about is freedom from birth. And this category includes people like Solomon Northup. So people who are living as free and who were kidnapped and sold into slavery can sue based on the fact that they were free from their birth or they were already free. It also includes people who can prove descent from a free mother because personal status follows the mother in the United States. And then also people of Native American ancestry. By the 19th century, Native American slavery is outlawed in the state of Missouri and in most states around the country. So that's another reason that they can establish that they've been free from their birth. And the second category is listed as manumission. So this includes people who had already been freed through a deed of manumission or through the will of the slaveholder. Sometimes when they die, they leave freedom to some of their slaves in their will. Sometimes people purchased their freedom. This was rare, but if they're able to earn extra funds, they might be able to save up and make an arrangement and buy their freedom. We also see arrangements or agreements that a person's going to work for a certain number of years, and after that time, or make a certain number of payments in the future, and after that time, they're going to be free. Now, as you might imagine, sometimes that those kinds of arrangements break down, and then oftentimes that results in a legal dispute or a lawsuit. And then the third category, and the most common by far when we look at the St. Louis example, is freedom because of residence in free territory. And with St. Louis's position or location right across the Mississippi River from Illinois, most of these cases refer to the people being free because they lived in Illinois, where slavery, for the most part, is outlawed with the state's 1818 Constitution. So these are the main categories of argument. That last one is based on an English doctrine from a case from the 1770s, saying that once a person's free, they're always free. Once you've gone to free territory, free state, that freedom attaches to you, and you cannot then be returned to slavery. And so after they present their petitions, enslaved plaintiffs, these cases have a whole range of different documents. Sometimes they have summonses for witnesses, sometimes they have depositions, those are the ones we really like because they have lots of rich testimony and detail about these people's lives and experiences. Sometimes they have a jury list and a verdict. They don't all have a verdict, so that's why we have a category up there for unknown. But I did everything I could to find verdicts, whether they were in the case files or not. And so the ones that have a verdict are what lead me to some of the numbers that are up here. And I just want to give you one explanation or caveat about the numbers. So there's quite a few cases that I've listed in the unknown category. And that's because some of them come, and at the end of the case file, there's a notation saying that the person allows their case to voluntarily be dismissed. And so in some of those cases, I've been able to establish with other research that those people do become free later. They have bonds or licenses allowing them to be free and live in the state of Missouri. In one case, they actually file another lawsuit later. You have to be free to be able to file a lawsuit in court. And so I'm able to establish that at least some of those people do make some kind of arrangement or manage to become free. And so I've placed those cases in the unknown category rather than in the category of plaintiffs not becoming free. So that's why that unknown category is a little bit bigger than perhaps you might expect. So I really limited the ones that say the plaintiff is freed to just the cases I could establish were freed by freedom suits, so in these particular cases. And so what I really want to communicate to you today is a sense of not only the complexity of these cases, but also some of the humanity that comes through, and the way that we get to see glimpses of people's life stories through the cases. And so I'm going to tell you a few stories, starting with a longer one. The rest of them are much shorter, I promise. And I'll use these then to explain some of the points of the book. And so we're going to start with a story of a woman named Alcy, who sued for her freedom in March 1841, sued a man named William Randolph. According to her petition, Alcy sued because sometime in the late 18-teens, her owner, Robert Cross, gave permission for his son-in-law to take Alcy from their home in Kentucky to Illinois and to live and work there as his slave. Now, as I mentioned, Illinois' constitution outlaws slavery with just a couple of minor exceptions, neither of which fit Alcy's circumstances. So if Alcy is taken to Illinois with her owner's permission, then she should be free according to the precedents that already exist by 1841 in the St. Louis cases. So Alcy brings several witnesses to confirm her story, saying that Cross's son-in-law, including, I should say, that Cross's son-in-law is one of her witnesses, who says that he has permission from his father-in-law to take her to Illinois, and that he holds her there for 5 years as a slave before he sells her. He falls into debt. He sells her to a man named William Campbell. So I have just the major characters up here to help you all follow along. William Campbell, who then takes her from Illinois back to his home in Kentucky and holds Alcy as a slave. Now the defense witnesses in the case challenge this narrative. They say that the son-in-law took Alcy without permission from Robert Cross, and that the son-in-law sells Alcy without any legal title, so he's not allowed to make this sale. Would make it a fraudulent sale and would doom her case, potentially doom her case for freedom. And so one witness for the defense testifies that he went with Cross to his son-in-law's house in Illinois looking for Alcy, but only after 5 years. So why does he wait 5 years to go looking for his slave if he didn't know where she was? So he goes to Illinois, and he learns that she's been sold, and then the witness and Cross go to Campbell's house, and they demand that Campbell return Alcy to them as Robert Cross's property. And William Campbell says no, and this is a quote. The witness says that he compelled us at the point of arms to desist. So in other words, he threatens them with a weapon, and so facing that threat of deadly force, they retreat. And Cross actually sued Campbell for possession of Alcy, and he does get her back. And so after that, Cross brings Alcy to St. Louis, where he sold her to prominent St. Louis attorney and circuit court judge Robert Wash, who then eventually sells Alcy one more time to William Randolph, who is the man who becomes the defendant in her freedom suit. Now, at some point after Alcy gets to St. Louis, she learns of her right to sue for her freedom. And her suit really illuminates several points that I'm going to make today. I'm going to keep coming back to it through the talk. But really, when she sues, she begins a whole process of legal actions that start with her case but don't end there. So one thing that her case illustrates is the interpersonal relationships that are going on behind the scenes in a lot of these suits. So one of the witnesses who testifies for Alsey is a slaveholder in St. Louis who had actually lost several freedom suits himself. So he lost several of his enslaved people to freedom suits, and he blames Judge Robert Wash for those cases. Wash was the judge in his case, and he has a bone to pick with him, if you will. And so he comes to court and he says that he is very sorry to know such a man, and his decisions against him were neither legal nor constitutional. And he offers $100 to Alsey to help her sue for her freedom, because he very much dislikes, that's a quote, he says, very much dislikes Judge Wash, and he's hoping that if Alsey wins her freedom, Judge Wash is going to be out of his financial investment. And so that just to give you one illustration of someone who's personally invested in the outcome. If a slaveholder who's lost his enslaved property to freedom suits is willing to put up $100, which is no small amount of money at the time, to help another woman sue for her freedom, but clearly there's a lot going on there. The other thing that Alsey's case shows is how additional legal struggles come out of these cases. So Alsey does win her freedom in 1843, and then she successfully defends an appeal to the Missouri State Supreme Court in 1844. And shortly after she wins her freedom, William Randolph, the defendant who has just lost his valuable investment, right, actually sues Robert Wash for selling him someone that he knew was free. And so Wash, for whatever reason, does not show up in court when the case is brought to trial, and so he loses the case. So Wash loses, and he has to pay back that money to William Randolph. Now, why a judge would not show up in court, why he would not know that that's a pretty important part of his case is beyond me. I'd love to know that. But he does try to get his case reinstated, and he appeals twice to the Missouri Supreme Court to try and reinstate his case and not have to pay that money to William Randolph. He is never successful with that. But he doesn't stop there. He starts writing a number of letters to Illinois looking for evidence that Robert Cross knew that Alsey was free when he sold her to Wash in St. Louis. So in other words, he's searching for evidence that he can use in a suit against Robert Cross. And he's never successful. He does not find any evidence. So ultimately, Judge Wash is the one left holding that debt and losing that money. But that illustrates, I think, not only these additional legal processes, but also the amount of money that's at stake here, right? So enslaved people at this time were being bought and sold for enormous numbers, enormously high prices. I don't have the exact figure in front of me for Alsey, but I would guess it's somewhere in the $500 to $600 range at least. And that translates to quite a bit of money in today's money, currency, I should say. And so, really, this case illustrates not only these additional legal struggles, the financial money that's involved, but all the things that are going on behind the scenes of any legal case. And so I use it to talk, and I'm going to use it to talk today about what I call the legal culture of slavery. And so the legal culture could mean all kinds of things, right? Culture is a very nebulous term. So like any good professor, I brought my definition. Here we go. I promise there won't be a lot of these text-heavy slides, but I just want to be really clear about this. So I refer to legal culture as the constellation of attitudes and experiences concerning law in a particular time and place. So this is separate from formal legal institutions like statutes or the cases themselves, although those are certainly an important part of the way that people think about law and talk about law and the way that communities understand law. But that's what legal culture is about. It's about how communities, how groups of people think about law and how law shapes their everyday lives and practices. And so encompassed within this is how individuals handle the law and think about law. So that's what some scholars have called legal consciousness. So that's about the individual, culture is about the community. So we see this in Alsey's case and in the examples of the St. Louis freedom suits. how the interworkings of communities can affect the course of these cases, but also the practices that happened before and after the cases as well. And so Alcie's story demonstrates, I think, very well how freedom suits are these hubs around which we have all kinds of legal actions, conversations, negotiations, arguments happening. And I sort of describe them as a web. So as these webs of personal interests, sometimes violence, power, and deception influence the course of each person's battle over slavery. So these struggles over slavery and freedom are not about just the enslaved individuals, although they're certainly the most important part, but that they have these larger repercussions for culture. And so I'm focused specifically on the legal culture of slavery, meaning those areas of law and legal practice related to enslaved individuals. Enslaved men, women, and children encountered the law in their daily lives through a variety of types of legal regulations and restrictions on their behavior, through things like property clauses that might mean that when an enslaver dies, they control over their labor transfers to someone else, and occasionally through lawsuits like these suits for freedom that we're talking about today. For example, enslaved individuals knew about limits placed on their mobility when they requested a pass to be able to leave their farm or plantation. And if they weren't given a pass, if they weren't giving written permission, documentation proving that they were allowed to move away from their farm or plantation or wherever it was that they lived, they could face physical punishment by the slave patrol. And I have up here just a couple of the badges that slave patrollers wore in the antebellum years. And so they knew that physical punishment was a real possibility. They also knew that when their owner died, it could lead to transfers, as I mentioned, of control of their labor, or sometimes even the auction block, which is the other image I have up here, and sale away from family, friends, and their homes. So given these dire consequences, and these are just two examples, but given the dire consequences I'm talking about here, really life or death in some case consequences, it should come as little surprise that enslaved people realized that knowledge of the law was paramount to their survival in a system of slavery, in the American system of slavery, and that they sometimes managed to make the law work to their advantage. And so enslaved men, women, and children are really central players in the processes of determining personal status. And so they're not the only ones, and we'll talk about that in a minute, but really it's the step that they take by initiating these lawsuits that lead to all of these processes that I'm talking about. So to go back to Alcie for just a second, to give you an illustration of legal culture through the case. So we see that legal culture working through the multiple conversations happening outside of the court, through the witness who came to court and offered money and support because he was angry at Judge Wash, through Judge Wash's writing letters to try to recoup his financial losses and such. And we see legal consciousness through Alcie's decision to bring a suit. So we don't know a lot about the details about Alcie and why she decided to sue. We have evidence from other people that I used to help kind of create a picture of why it was that people sued, and more importantly, what was at stake for them. So it may make sense to us that if someone has grounds to sue for freedom, of course they're going to do that. But doing so was a big risk. Some of the people that sued were sold away from St. Louis before they could finish their case. Some of them were physically punished as a result of that. Some of them, in one case, we have a young woman who was forced to go alone by herself to the docks at night and run errands for her owner. That's what she describes to the court. I can only imagine what she doesn't describe to the court. And many of these plaintiffs actually spend the vast majority of the time while their cases are being prosecuted in the St. Louis jail, which if none of us have ever been to a 19th century jail, and none of us want to. They were not fun places. So my point here is Alcie had to make a number of considerations and think about it before she filed this case for her freedom. And those kinds of considerations and her experiences that led her to sue are part of her legal consciousness. The second major point I want to highlight today is about mobility. And Alsey's case also shows this pretty nicely. So she lives in Kentucky, she moves to Illinois, she's taken back to Kentucky, and then she's forced to migrate to St. Louis. And it's those movements that allow her the grounds and the opportunity to sue for her freedom. And so I'm going to tell a second story that also illustrates the point about mobility, and that's the story of Thornton Kinney, who sued for his freedom in St. Louis in 1853. Kinney was born in Virginia to a Native American descended mother, so he was born free in Virginia. And when he turned 21, he got a copy of his free papers, and like so many people in the antebellum era, he decided to join the movement west and begin a career working on steamboats on the Ohio and Mississippi rivers. And so he goes and he's working on steamboats, and he travels through St. Louis, and while he's in St. Louis, he meets an agent of the American Colonization Society. Now, if you're not familiar with the American Colonization Society, they're a group who forms with the idea that they're semi-anti-slavery. They want to free people, but they also want to move them to Africa. So they believe they're opposed to slavery, but they also can't imagine having people of African descent as part of American society. So they raise funds, and they actually do move and colonize people on the coast of West Africa. And so Thornton Kinney meets this agent who convinces him to migrate to Liberia. So he moves to Liberia, and he lives there for 5 years. Now, while he's there, he destroys his free papers, and he thinks that he isn't going to need free papers anymore. He's living in a place where there isn't, where he was not legally enslaved. And also, and this is a quote because I think it's a great description, he says that they were so worn and mutilated that no one could decipher them. I mean, how many of us have had a piece of paper on us that after a time it's just not really readable? Maybe it's just me, but so I can really imagine how having your free papers from age 21 and working on steamboats and moving to Liberia, they're going to get a little bit worn out. But he does decide, he doesn't say why, but he does decide to come back to the United States after 5 years, and he goes back to working on steamboats on the Mississippi and Ohio rivers. But right when he comes back, he realizes that he's vulnerable, right? He no longer has those free papers. And so he approaches a court in Louisville, Kentucky, and proves and registers proof of his status as a free man with that court. And then he also registers similar proof with a notary public in New Orleans. And then goes back to working on steamboats as he was before, as a cook and a steward. He marries a free woman of color in St. Louis, and he is eventually captured by a steamboat captain who claims that he's his slave and has him imprisoned in a slave pen in New Orleans for sale. Now, while he's in New Orleans, the slave trader tries to sell him, and this again is a quote. He says that he could not succeed for the reason that he, meaning Kinney, would always tell anyone who spoke about buying him that he was free. So he's able to keep from being sold there, and then he makes a daring escape out of the window of the slave pen and goes back to his job, to what he's known his whole life, to working as a steamboat cook. Eventually, the steamboat captain does catch up with him, has him imprisoned as a runaway slave in St. Louis, and that's where he sues for his freedom in 1853. Now, despite all of the contacts he's made and the work that he put in to establish his free status, Kinney's case is dismissed in December of 1855 because he's not able to put up those financial resources that I mentioned after that 1845 law that I mentioned at the beginning. His case is dismissed, and despite I've looked absolutely everywhere, I have not been able to find out what happens to Kinney after this point. If anybody knows, please tell me. It's definitely one of those cases that I looked high and low to find. Kinney, I can only hope that having his case end in 1855, that he lived another 10 years to see emancipation. But I tell you Kinney's story to illustrate how he lives in what I call a world in motion. So the 19th century United States sees countless people moving around, right? We have tons of, this area, I don't have to tell you guys that, you have tons of migrants coming west. You have people passing through Missouri and going to California, to Oregon, and to various other places. You have the domestic slave trade picking up, and lots of people of African descent being moved from states in the upper South to the deep South, to places like Alabama, where I'm currently living. And so this world in motion has a lot to do with these cases, because when people are moving around these different places, they're also crossing legal jurisdictions. They're crossing between different legal arenas. And they force questions about law and how it's going to work, and how one state's going to deal with another state's laws. They force those questions into court. And so freedom suits really highlight how these individual migrations sometimes force states to debate and to clarify definitions of personal status. Now this is what some scholars refer to as interstate comity. That's C-O-M-I-T-Y, not comedy, it's not necessarily funny, but comity refers to how one state is going to respect another state's laws. And for most of the antebellum period, we see that working. Comity works here in Missouri, and that's why we have so many people who are able to sue based on Illinois' laws or based on free states' laws. And it's only in the late 19th century that we see this break down. So by traveling across these geopolitical borders, enslaved individuals and enslavers challenge the relationship between local legal arenas. And so one of my chapters in the book deals specifically with mobility and geography and these issues of comity. And so comity does break down on the eve of the Civil War, but before that it serves as kind of a legal glue holding the North and South together. And so only when it breaks down do we have secession, but perhaps nowhere is that more apparent, that glue and how it works, than in a border region like Missouri. Now, as I mentioned at the beginning when I was talking about Alcey's case, there are a whole bunch of people involved in each one of these legal cases. So we typically think of lawsuits as two-sided contests between a plaintiff on one side, a defendant on the other. Yes, sometimes there's lawyers and a judge maybe, but typically we think of them as being two-sided. But I would argue that there's a whole host of contributors to the legal culture of slavery that develops through these cases. And enslaved men and women are not passive victims of this, they are active participants in this conversation. And so alongside these enslaved plaintiffs, we have attorneys, judges, former slaveholders, community members serving in a variety of roles. And I'm not going to talk about all these groups, but I'm going to just quickly touch on a couple of them to illustrate the point. So I want to start with the story of the woman on the left here, Lucy Delaney, who is the only person that we know of to write about her experience suing for freedom in St. Louis. And she writes about it in her memoir, From the Darkness Cometh the Light, which she writes in the late 19th century. And so I'm going to read this, I promise it's a short section, but I quote extensively from her memoir, and I want to make sure I get it right. So we pick up this when she's sitting there towards the end of her case, and she's waiting to hear what happens. Basically, she's waiting for the verdict to come. As young Lucy Delaney waited for the judge to announce her fate, she trembled in her seat. She later described the scene as, quote, a bright sunny day, a day which the happy and carefree would drink in with a keen sense of enjoyment. So the opposite of the weather today. But she said, my heart was full of bitterness. Lucy recognized the gravity of her situation. Within minutes, the judge would announce the jury's decision and declare her legally free or return her to enslavement. I could not tell one person from another, Lucy wrote. Friends and foes were as one, and vainly did I try to distinguish them. I felt dazed, as if I were no longer myself. Lucy sat bewildered as the trial resumed, and her lawyer made an impassioned and insistent plea for the court to release her. The judge agreed to release her after reading the jury's verdict and granted Lucy her freedom. In response, the defense attorney leapt from his seat, this is from her description, leapt from his seat, demanding that she be returned to jail so he can institute further proceedings. And if you've ever watched Law & Order, I just picture one of those episodes where they're so mad they just jump up and start yelling. That's what's going on. And in Lucy's description, it's her attorney who settles this guy down and successfully argues against him that she should remain free. Lucy later expressed some sense of the overwhelming joy she felt at the time. Oh, the overflowing thankfulness of my grateful heart at that moment. Who could picture it? None but the good God above us. I could have kissed the feet of my deliverers, but I was too full to express my thanks. And this triumph she's describing follows 17 months sitting in the St. Louis jail, awaiting trial, years of contemplating how to escape her enslavement, and a lifetime of abuse and slavery. And one of her deliverers in her telling was her attorney. You may recognize on the right here, this is Edward Bates, who becomes a little bit more famous when Abraham Lincoln hires him as the Attorney General during the American Civil War. So attorneys are really important to this process. Attorneys were responsible for filing paperwork, for finding witnesses, and for deposing them, sometimes even paying their own money to travel far from St. Louis and take depositions in their clients' cases. And so some attorneys do go to great expense and effort to prosecute the cases, while others destroy the cases by failing to even show up in court. And at that point, those cases are dismissed, and that's the end of the story for several of the plaintiffs. So the choice to strongly pursue a remedy for their enslaved clients or to neglect the cases altogether had life-altering implications for the individuals bringing these suits. And so attorneys really join the cases for a variety of reasons, and I don't really have time to get into those right now, but my point is that their level of commitment is really important. In an era where the law seems stacked against enslaved people, attorneys in freedom suits could help plaintiffs carve out a measure of autonomy by challenging their enslavers in court. Or they could essentially doom their case by failing to pursue them, by failing to file the proper paperwork or even to show up. Like attorneys in freedom suits, the local communities influence the cases in a variety of ways as well, giving testimony, serving on juries, sometimes providing some of the financial resources that I mentioned to help them prosecute their cases. We know Dred Scott had help from community members in prosecuting his appeal to the U.S. Supreme Court, for example. And so testimony in court is really, I think, the most obvious way that we see community involvement. And so I'm just going to very quickly finish with a couple of stories to illustrate how testimony could work for or against enslaved plaintiffs. And the first story I want to tell you is George Johnson, his case from 1852 against Reuben Bartlett. Johnson was from Pennsylvania. He was, again, born a free man, and also, like Thornton, Kinney, worked on steamboats. It was a very common occupation for folks in St. Louis at the time. And so he moves to Missouri, spends 8 years working on steamboats, and then eventually gets caught and captured as a runaway slave, and he sues for his freedom. And so Johnson drew on his relationships both on steamboats and especially the people he knew in Pennsylvania to prove his freedom. And so one witness testified that he knew Johnson in Pennsylvania, where he was, quote, considerably smaller, and that the two of them played together many a time, and that he was always under the impression that he was free, of course. Another witness testified that his, quote, impression was that he was a free man because he acted for himself. So these two witnesses are both from Pennsylvania, and yet they're not testifying about the fact that they're from Pennsylvania, which is a free state, and according to this doctrine from earlier that we've been talking about, should be enough to prove Johnson's freedom. Instead, they're testifying about his reputation, about whether or not he seems like a free person. Did he act like one? Did he play with free people? And sometimes we see testimony about wages, where they paid wages, and that could be used as proof of freedom. And so really reputation is an incredibly important part of antebellum society. And so that kind of testimony that the person acted like they were free or appeared to be free could be very significant to their winning their case. Now on the flip side, we have the example of George Ruff, who sued Thompson Ficklin in 1828. I'm just going to read you a little bit of testimony from one of Ralph's former owners. And he says that, quote, "After he had made a second attempt to commit murder on the family of this deponent," meaning the owner, "this deponent drove the said George from his house and declined having anything farther to do with him." Now, I have no idea why it took a second murder attempt for him to decide that he needed to maybe remove this person from his house, but it was 2 attempts. So in giving a little more detail about the attack, the witness recalled, quote, "George advanced into the room where the deponent was and some company were sitting, with an arm elevated in a striking position, meaning he would kill the rascal. This deponent sprung towards him and with great difficulty avoided the blow." So you can kind of picture the scene. And 3 years later, the witness tells of another episode where Ralph threatened to shoot one of the other slaves with a gun, and then also threatened to shoot his owner when he tried to intervene. And it's only after that second attack that the witness testifies that he feared for his safety, and so he sells Ralph to a slave trader. But the point here is that this testimony is being used to impugn the character of George Ralph, to keep him from becoming free, because he doesn't seem like he should be free. He's committing murder. That's not something that should result in freedom. And so this testimony by community members serves as an important reminder that more is at stake in freedom suits than the determination of a single person's freedom. These cases are really about how communities view people and how these people are going to become a part of a community when their cases end. To conclude, determining the future of slavery in the United States was the major issue, the central question of the antebellum years. Although freedom suits were disputes over the personal status of an individual plaintiff or sometimes a group of plaintiffs. We do have cases where families sue together and where groups of people sue together. The individual men, women, and children who participated in these cases contributed to these foundational debates over the meaning of slavery and freedom and the role of African Americans enslaved and free in their communities and in the nation. Freedom suits occurred throughout the slaveholding states and before the American Revolution in the colonies as well, making them not necessarily common occurrences, but certainly a well-known aspect of the law of slavery. As the initiators of these lawsuits, enslaved plaintiffs shaped the content and direction of these discussions, making their mark on the political landscape. That their lives, these are people whose lives left few traces in the historical records, and with the exception of Dred Scott, they are largely absent from conventional histories of this era. The stories that emerge from the case files speak to the networks of interactions that took place both inside and outside of the courtroom, but also demonstrate how the efforts of these enslaved plaintiffs allowed them to wrestle small concessions from enslavers and to set precedents for future litigants. So in other words, they allow them to contribute to the legal culture of slavery, and I would argue they should be in those conventional histories for that reason. Thank you.